An experience about intestate proceedings. I think I was not yet with the government service when that case was filed before my court. It was terminated when I was to leave my court as an RTC judge. I was able to
effect a compromise.
Yes, effect a compromise because some of the compulsory heirs died already. It's in the records. The publisher of Iskra. I think you know the publisher of Iskra.
Yes.
But the problem in succession really is sometimes it's the rules. Is it not? It's the rules. Why? Because we allow multiple appeals.
Yes. In special proceedings, multiple appeals
Yeah.
are allowed, as well as in
sometimes
expropriation.
If,
yes.
Sometimes the main case is pending before the court, and the party raises an issue as to whether or not that is a compulsory heir. You go to the Court of Appeals, you cannot move. You cannot distribute because you will have to determine
Yes.
if he's a compulsory heir or not, or illegitimate or not, or he's an heir or so what.
Yes. Testate cases
then
do
you have
take
to
very
wait.
long. Yes.
So
Your
what should be done? If you come here, what should be done with those rules?
I'd like to tell you my favorite Supreme Court case. It was the case was already in the Supreme Court, and the question was the delay in the filing of the petition for review, and it was revealed to the Supreme Court that the reason why there was a delay in the filing of that pleading, which caused the dismissal of the case, was because the wife of the lawyer had passed away. And that Supreme Court case is kind of relatively old. The Supreme Court devoted, I think, about 10 or 20 pages talking about how it is to lose a loved one and what a tragedy it was that probably was really a good reason for the lawyer to have missed filing the pleading on time. But then in the end, the court said the case is dismissed. Yeah. To me, it's a good way of showing how justice should be done, how the rule should be applied. You can't really be solving all these problems about delay and congestion if you do not apply fairly standard or uniform rule that if appeal is not right, that if you miss filing the pleading within the prescribed time, then there's no choice but to dismiss it. The problem sometimes is petitions are evaluated differently by judges, from one judge to another, from one division of the Supreme Court to another, so that the result is not uniform all the time. So sometimes there were times that it was very strict and would dismiss all petitions which do not even file legibly clear copies of the attachments. Then there was a time when anybody who, there was even a time that certifications or verifications signed by lawyers rejected and caused the dismissal of petitions. Those are really good rules because they would decongest the docket of the court, especially the Supreme Court. But I suppose that in the implementation, it should not vary from division to division or justice to justice, judge to judge. It should really be equally applied. And even if it's harsh, as in the case of the lawyer whose wife died and was not able to file the pleading on time, I think whatever is provided for should be applied.
Yeah. Whatever it is, or a test, of course, you're qualified to be Chief Justice. Whatever it is,
Thank you.
I will request Attorney Rolly Bindowan to recommend you to become a member of the Mother Committee.
Yes, for the revision of the rules. Yes.
Yeah.
I think you already on special proceedings because that's I
think so. Now my last question, no, you may or you may not answer my last question. Is there an advantage of an unmarried woman Chief Justice over that of a married woman Chief Justice?
No, Your Honor. I think it's the same as what we follow in ACTA. You just have to be prepared for your cases. In your case, if you're the judge, then you have to read all the documents and go through all the evidence presented.
But you will have more time.
Yes, I believe so, Your Honor.
On that note, thank you. Thank you,
Thank you.
Chairperson Herbosa. Thank you very much
Thank
for
you.
coming.